Enfim, bem-vindo a todos os integrantes do nosso comitê e participantes aqui desse evento. Hoje nós temos dois convidados muito especiais, que a Mariana Vilela vai apresentar aqui para vocês. A gente vai fazer essa primeira parte do evento, então, das 10 às 11, que a gente vai ter a apresentação desse report sobre Whistleblowing. E depois, às 11 horas, a gente tem a reunião, segmento aqui nesse mesmo link, da reunião do nosso comitê. Eu peço a todos os participantes que quiserem fazer perguntas, para deixarem as perguntas no chat, e eu e a Mariana vamos acompanhando aqui e endereçando as perguntas aos convidados. Então, agradeço a todos. Thank you, everybody. Please, Mariana, you can start.
Hello, everyone. Good morning. It's a pleasure to be here today. I will start by introducing our guests. Samantha Feinstein is the staff attorney and deputy director of the international program at Government Accountability Project. She develops and advances private sector whistleblower rights legislation. She represents public, private, and international whistleblower clients and conducts research, training, advocacy, and public education for the international program. She has 21 years of experience, including extensive work in international law and development on anti-corruption, international access to justice, good governance, human rights, and humanitarian aid. Before joining Government Accountability Project, she worked at the American Bar Association section of International Law and the ABA Rule of Law Initiative. Samantha has also worked at International Rescue Committee, Bain Global, and she was Middle East Policy Advisor for Nij Deva, UK member of European Parliament. I probably spoke that wrong. My pronunciation is not, no?
That was perfect.
Samantha holds an MA in International Relations and a JD, and she's admitted to practice in Washington, D.C. Samantha, thank you so much for agreeing to join us today. It's really a pleasure. And Tom Devine. Tom has, since 1979, been the Government Accountability Project's legal director, where he has assisted over 8,000 whistleblowers and has not lost a case since 2006. He also has been on the front lines for passage and oversight of 36 whistleblower laws, including nearly all U.S. federal laws, and internationally from Serbia to the UN and World Bank, most recently the EU Whistleblower Directive and Ukraine. He's an adjunct professor at the DC Law School, has been recognized annually since 2012 by the Metropolitan Washington Lawyers Association as one of Washington, D.C.'s top employment lawyers, appears regularly as a media expert, has authored numerous books in law journals, and spoken in over a dozen nations as the State Department's informal ambassador for whistleblowing. So thank you very much, Tom, for joining us. Again, it's a pleasure to be with both of you today. The idea to have both of you present this report has been raised within our committee, because I think that this is a topic that we all are interested in learning more, and also to have the overview of the work and of the laws that you have studied and your experience. I think it's going to be very relevant to our group here. So thanks again. Maybe Priscilla, you can start so they can start the presentation. Thank you very much.
Okay, thank you again, Mariana and Samantha and Tom for being here. I would like first to ask Samantha to present the findings of this report, but before she starts, I think it's important for all of us to understand what are exactly what we are talking about. What are whistleblowing laws? Here in Brazil, as you may know, we have a very strong leniency program. And then I see that we have among our participants some people that work for CADE, the Brazilian Antitrust Authority, who are responsible for this program. And but I'm not sure. I believe that we are not talking about the same thing. So I would appreciate if Tom could explain to us what is whistleblowing law and talk a little bit about the project. And then Samantha, you can follow. Thank you.
Thank you very much. We're in the midst of a global legal revolution for whistleblower law. So it's a very pertinent question. When I first came to the Government Accountability Project in 1979, the United States was the only country in the world with a whistleblower law. And the second one was until 1998 in Great Britain. And now we have 49 nations with whistleblower laws. And actually, that's 63 nations if you count the European Union Whistleblower Directive, which was passed in December 2019. So this is a phenomenon. But to kind of get a grasp of what it means, I think we first have to define what's a whistleblower before we go into the laws protecting them. And this is a concept that's as old as the history of organized society. We used to call them dissidents, and we still call them dissidents in other nations, depending on the topic. But as long as institutions have had power, sooner or later, there's been an abuse of power. And sooner or later, the abuse of power gets so severe that people say, I'm not going to accept this, and I'm going to assert myself and challenge it. If they do it with weapons, they're called revolutionaries. If they do it with words, they're called dissenters or dissidents. Whistleblowers are kind of a specialized form of dissidents. These are people who use free speech rights to challenge abuses of power that betray the public trust. In other words, they're serving as the eyes and ears of the public to defend the public against threats from our own institutions. That gives them a very unique role in society. And it's also a very difficult choice, kind of like a personal and professional life's crossroads for most of the people who exercise this right. Because they're at the intersection of a lot of valid but conflicting values that we're all raised with. For example, we're raised that it's good to be a team player. We don't like people who are troublemakers and naysayers. But on the other hand, we're raised that it's good to be true to yourself. You don't want to be a bureaucratic sheep who just goes along with the crowd. Well, whistleblowers sometimes have to choose. We're raised that it's bad to be a squealer, to expose things from your colleagues or your friends. It's a tattletale, rat. But on the other hand, we don't have much respect for people who say, I don't want to get involved, who look the other way. One of America's greatest disgraces was when someone was raped in public and everybody closed their shades. They didn't want to get involved. We say that people like that are see no evil, hear no evil, speak no evil. They're like monkeys. They're not humans. Well, whistleblowers decide, well, am I going to be a rat or a monkey? Not an easy choice. We value the right to privacy, but there's the public's right to know. There's the contradictions of loyalty. You have to be loyal to your family. That's your main duty in life. And you want to be loyal to your colleagues where you work. But what about being loyal to your community? If your community is being betrayed by something at work, or loyal to the law, you might be liable for joining the cover-up, or loyalty to your country. So many whistleblowers are motivated by patriotism, because they knew that our people are being killed, not by the enemy, but by our own corruption. Very, very difficult choice for whistleblowers. And they have to decide what's being true to themselves to make that choice. Once they've made it, they've got to rely on legal rights. And although we're in a legal revolution, like any new concept, there's intense growing pains. And that's the reason Samantha and I teamed up with the International Bar Association to do this study. Now, we say these rights are like free speech shields, and there's two types of shields that we've discovered from our research. If you go into battle with a metal shield, it's going to be very dangerous, but you got a fighting chance to survive. If you go into battle with a cardboard shield, no matter how beautifully it's decorated, you're going to die. And so many of the new laws have been cardboard shields. They're false advertising. They're almost like traps. And the big challenge for our movement right now is separating so that we know what's necessary to have credible rights and which nations have actually enacted them in good faith rather than putting up false advertising. The four cornerstones for credible rights are, first of all, they're there when you need them. There aren't loopholes, that you can have free speech, exercise free speech to the audiences who need it when they need it. The second is there's credible enforcement channels through administrative remedies for those who can't afford due process, access to a genuine day in court for those who can. The third is remedies, so that if you win your case, you actually win. You don't lose by winning because the benefits are so shrunken. And fourth, credible corrective action, so that there's a realistic chance to make a difference when you stick your neck out and risk your professional life. That's the whole point of it. That's the four cornerstones for an effective whistleblower law. And I'm going to turn over the program to my partner, Samantha, now to describe the study that we did to assess these laws.
Thanks so much, Tom. So I want to begin by just letting you know, and some of you may be interested, that one of our co-authors from the International Bar Association is a Brazilian citizen, and she's with us today. So Rafaela Nawa, she was one of the vital people who worked with us on this study. We worked, as Tom mentioned, hand in hand with the International Bar Association. We co-published this report together. And it's a large report that was several years in the making. And part of that is because there's two major components of this study that were both very comprehensive. One was looking at 48 national whistleblower laws and comparing them against 20 best practice standards to see what are the quality of these paper rights. And then there's kind of part two, if you will, of the study, which looked at the effectiveness of whistleblower laws. So we sought to look at all of the whistleblower retaliation cases in each country to see how well it's being implemented in practice. Are these laws actually protecting whistleblowers from retaliation once they're passed? For this part of the study, we looked at 37 countries across 21 different languages. So we relied on a lot of volunteer legal researchers to help us because there were so many cases to review in different languages. And the background, I have all of the different jurisdictions that we covered in the Americas, Asia and the Pacific, Europe, Africa, and the Middle East. And these are the different jurisdictions that enacted what qualified to us as a comprehensive whistleblower law that was enacted up until 2017. So it was enacted before 2018. We took a look at the cases to see how it was working in reality. But for the review of the paper rights, we opened it up so that some of the new laws, like in Lebanon or Croatia, could be considered as well. So as I mentioned, there's sort of two phases of this project. The best practices is something that was developed by Tom. He's going to talk more about that soon in alignment with the G20 and the OECD, who have very similar standards that we all agree upon. We looked at cases up from the time that the law was enacted up until 2018. And we did this because actually we found, and I'll talk more about this soon, that there were so few cases to look at. So we really opened it up to see, what activity, if anything, are we seeing under these laws? But for the United States and the United Kingdom, kind of opposite, there were so many cases that we selected a 1-year period to look at cases in the UK and the US, because it was a very different situation. So we took a look at different court websites, agency websites to find cases or reports that mentioned cases. If necessary, we looked at academic research. We also sometimes contacted court clerks for help finding cases, as well as different government agencies and different international or national watchdog organizations and different law firms as well, where we couldn't find cases very easily online. And there's kind of 4 sort of main trends, and I'm going to unpack this a bit more for you soon. But generally, we found that there was a lack of access to information. There's many countries that don't have, electronic court systems where you have a case decision, for instance, readily available and searchable. So it was hard to find what is the results of these whistleblower cases and really read these decisions ourselves. And there was also a lack of utilization of the laws. So a lot of them were passed and then pretty much were kind of dormant. And there's kind of several factors that may be contributing to that. And there's also really low rewards for whistleblowers. So, our study showed that by and large, the majority of whistleblowers lose their cases if they're bringing a retaliation case. But when they did win, the remedies were so low. And that's really significant because we have other findings in this study about cases dragging on for years and years. And so you see the kind of costs beyond just the emotional cost as well of dragging these cases on. So these are the kind of main takeaways from our study. But Tom is going to talk a little bit more to start about our study of whistleblower paper rights and how do they compare with best practices, the 20 best practices.
Thanks, Sam. And in overview for my next presentation, I'd like to also credit one of our friends and partners from Brazil, Marcio Rocha, who's an appellate judge in your nation, actually invited Government Accountability Project and other U.S. groups down to help develop a whistleblower law for Brazil a few years ago. And my understanding is that it came within a few votes of passage, it didn't, but that your nation did enact a False Claims Act, which is a narrower version of whistleblower laws to challenge fraud in government contracts. And so I've been a big fan of an appellate judge in Brazil who's been a crusader for freedom of speech. And I'd also like to emphasize another aspect of our findings in our study. These laws are almost never used. While we've had a global revolution in free speech rights with checkered quality, it's basically a dormant resolution in all but a few nations. And that's one reason Samantha and I are so excited about the opportunity to get the word out. The times are changing, but how much they'll change and in what direction is still an open question. And let's go into then the laws that determine whether freedom of speech will start having the revolutionary impact in reality that it has on paper. They said the first cornerstone is rights that are there when you need them, call it scope of coverage. And the first criteria for that is free speech rights with no loopholes. There can be arbitrary loopholes tucked into so many of these laws that are based on formality, context. Formality, you don't have rights if it's oral instead of written, or you don't have rights if you don't put down your address in the disclosure. The timing, I say it was too long ago, it was last year. You don't have any free speech rights there. The audience, you need to have public freedom of expression, at least at some level, for some context, for the law to be effective, because whistleblowers are warning the public oftentimes that they've been betrayed. When you have all these loopholes, there's confusion and uncertainty for whistleblowers when they have rights, when they don't, and it means there's going to be a chilling effect and the law won't be used the way it should be. The rights have to be there whenever they're needed. The second is subject matter with no loopholes. Some laws are just about corruption. An effective whistleblower law will be protecting against any abuse of authority or mistakes or mismanagement that's undermining the public. Maybe it's not even an intentional mistake, it's just incompetence. But you need free speech to expose it and correct it. And so that means an effective law will protect challenges to illegality, any human rights violations, abuse of authority, mismanagement, which is incompetence, gross waste, not getting any benefits for the public's funding, and threats to public health, safety, or the environment. The third kind of criteria we say is the right to refuse to violate the law. Some nations have this, the United States does, but it hasn't taken root as much. But it means you can do more than just make noise. You can walk the talk, and you can follow through and act on your dissent. The fourth thing is protecting what we call against spillover retaliation. There was a book written in the United States by Hillary Clinton, former Secretary of State and presidential candidate, that's what the title was, "It Takes a Village to Raise a Child." And actually, it takes a village to make a responsible, effective whistleblowing disclosure. One person, it's not realistic for them to know everything that's necessary to draw the right conclusions or to prove them. There has to be a team that's providing evidence and information. There have to be people who are assisting that whistleblower. And the whistleblower is the spokesperson, the messenger for that team, not just the sole isolated individual. And you need to protect the whole team, not just the messenger, or else the whistleblower is going to be isolated in a very dangerous position. It'll be dangerous to even be seen with that person, to talk to them, to be associated with them. The whole team has to receive protection. The fifth is you need to have a protection for anyone who's supplying evidence. A lot of the whistleblower laws are just for employees. Well, what difference does it make whether it's a citizen whistleblower or a worker whistleblower who's exposing an abuse of power? Anyone who supplies the evidence should be covered. The sixth criteria is you have to have reliable confidentiality protection. For many people, this is going to determine whether or not they remain silent observers or whether or not they try to make a difference, because they don't want to be exposing themselves and their family to retaliation. And if they're not identified, that will prevent the reprisals from occurring, at least until the case is very, very far along. They may have to testify in court or something. The seventh criteria is protection against unconventional harassment. And I've learned from doing this for 42 years that the forms of harassment are limited only by the imagination. And I've never stopped being impressed by the creative ingenuity of bullies. You make a list of 10 things that are illegal to retaliate with, they'll come up with another 10. So there has to be all-out rights that any discrimination that would create a chilling effect on freedom of speech, responsible freedom of speech, that is illegal in violation of the whistleblower law. The eighth criteria is protecting whistleblowers from gag orders. It's not unusual for nations to pass a whistleblower law, but then there'll be another law that cancels it out, kind of a more general law, like an Official Secrets Act. Or it may not be the government, but as a condition of your job, you have to agree to waive all your rights and get advance permission before you say anything about anything. Well, those gag orders will erase the whole impact of the whistleblower law. And an effective one has to have what we call an anti-gag provision. It says in the event of a conflict, the free speech rights in the law prevail over any conflicting orders or legalities. Unless there's a new law which specifically amends or cancels the whistleblower law. Of course, any legislature has that right. But in the absence of that extraordinary action, the whistleblower law wins in the event of a conflict. The ninth criteria is providing support services for the paper rights. People have to know about their rights. They have to understand them. There's oftentimes a lot of almost like I say, negative advertising or even propaganda by the power structure against freedom of speech through whistleblowing. The public has to understand that these are people who are defending communities, not betraying them. They have to be aware of the existence of their rights. They have to know them, so they know the boundaries and can use them effectively. The people who have to respect those rights and obey them, they have to be aware of them and understand and be legitimate. And then when you try to act on them, there needs to be some agency for an unemployed whistleblower to help guide them and navigate them through the process. That's that kind of background context is essential for the rights on paper to take root in reality. Well, that leads to the second basic cornerstone, your enforcement forum, the right to a genuine day in court. And really what we're talking about here is due process, whether it's at an administrative level or in a court or before a human rights commission, that you can, in a formal proceeding on the record, publicly on the record, you can present your evidence, confront and cross-examine your accusers, and receive justice from the same institution that would be providing legal rulings, judicial rulings on the misconduct that you're alleging. There should be an alternative for mediation or informal proceedings to enforce your rights. And there has to be effective rules of the game when you're in there. One of them is a statute of limitations. You have at least 6 months, and the best practice is 3 years to act on your rights. Many people don't even know they have them until it's too late to act on them. And then realistic standards, legal burdens of proof. This is the rules of the game for what it takes to win. And if you only have to have this much evidence, it might be realistic. You have to have this much evidence, it doesn't matter. You don't have a chance. The burdens of proof can mean that you have a fair chance or that the rules are rigged. And the basic rules of burdens of proof means that, and then what's been adopted by the European Union in 2019 is if you engage in protected whistleblowing and something happens to you, something discriminatory happens to you, the burden of proof then shifts to the employer or the government agency to prove that whistleblowing was not relevant to the action that was taken. It's not even enough that it's only 30% the reason. You can't be partially illegal, canceling freedom of speech. Those burdens of proof are an essential cornerstone. The third major area is relief for those who win. No loopholes compensation, that you at least are compensated for the direct and indirect consequences of the retaliation, like lost income, but also emotional distress, lost credibility and reputation in your professional community, all the things that mean that you are worse off because you blew the whistle. You should be able to get relief for. There needs to be interim relief there too. What do I mean by interim relief? Temporary relief, like an injunction. These cases, as Samantha is going to go out, they can go over 10 years sometimes. And if you don't have temporary relief, it's not going to matter when you finally win. You know, it's like the patient who dies before the world famous heart surgeon comes in for the transplant. It's too late. You've already lost your home. Your family may have broken up. You've gone bankrupt. Your professional credibility is destroyed. There needs to be temporary relief while the facts are sorted out for these laws to be effective. And the fourth cornerstone then is corrective action. It means there'll be accountability for those who violate the law. It means that there'll be a realistic chance to make a difference. That the whistleblower can't just make noise and be safe making noise, that they're enfranchised as a participant in the process to act on their concerns. They can rebut the denials that everybody who's engaged in wrongdoing is surely going to make. The whistleblower will be there to call the bluffs. They can comment on the adequacy of the report that's made. And then the report and action that's taken be public, that it be transparent and available to the public. These are the four basic cornerstones for an effective whistleblower law. And they translate into the 20 criteria that we assessed nations as having. And as a general rule, nations were complying with anywhere from a third to half of these criteria as a general rule. A few nations like Serbia and Australia and Ireland comply with almost all of them. There's a few nations like Canada and Lebanon that almost comply with none of them. We've got a wide variation in the quality of free speech rights right now. And that explains why we have such a dramatic variation in the results of how effective they've been. And that means that it's time for Samantha to start going into the results of our research.
So some of our research found that there was very little utilization of whistleblower laws. So we found that 59% of countries in our study had no reported whistleblower decisions at all. And we also found that 89% of countries in our study had fewer than 15 publicly reported whistleblower retaliation cases. So overall, we found that these laws have been dormant. There's kind of two countries that we classified as medium use countries, which is South Africa and Japan. Now, South Africa enacted their whistleblower law in 2001. So keep that in mind. And since then, we found 33 final decisions in whistleblower retaliation cases. And in Japan, which enacted their law in 2006, we found a total of 30 final decisions in whistleblower cases. Now, in the United States and the United Kingdom, as I mentioned earlier, there was a much larger number of cases. So in just 1 year alone, we found that there was 135 cases, and in the UK, there was 224. It's just worth noting that Northern Ireland has a separate law. And there were 4 cases that we found in Northern Ireland's whistleblower law. And again, as I mentioned earlier, there's a very low success rate for whistleblowers in the United Kingdom. In 2018, we found that only 13.8% of whistleblowers won their retaliation cases. In the United States, overall, it was less than 10% of whistleblowers in kind of a selection of private and public sector whistleblower laws. I think we have over some 60 different whistleblower laws in the United States. So we kind of opened it up to as many as possible and examined the full breadth of cases in the United States. In Japan, whistleblowers only won 4.5%, and in South Africa, it was 21.2% of cases. Now, there's some exceptions, but it's sort of exceptions with a question mark, because in Norway, 100% of whistleblowers won their cases, but it was only one case. And in Romania, 100% of whistleblowers won their case, but the sample size was only 6 final decisions in whistleblower cases. And in Serbia, there was an 80% success rate, and that was out of 15 cases. But I think I kind of have to footnote here that in Serbia, they didn't have public access to case decisions. So we worked with a volunteer researcher from Pištalka, which is the leading whistleblower protection organization in Serbia that represents whistleblowers in their cases. So they were able to kind of look at their cases and there may be some indications of, when a whistleblower, for instance, has good and affordable legal assistance, that they are probably more likely to be successful. So there's also sort of a caveat there, although, overall, it seems like the indications in Serbia are positive for an effective whistleblower law. And it's something that Tom spent a lot of time working on developing. Now, we have some key recommendations I wanted to share with you that are takeaways from this study. First is that we recommend that countries publish case decisions online with a searchable database. And this really helps with being able to monitor how these cases are working in reality. And it really helps us assess if these laws are working as they're intending to, because from the indications, at least that we have so far, it doesn't seem like the laws are working as they're intended to, if they're intended to protect whistleblowers. So we also recommend that governments publish reports with consolidated information about the impact of whistleblower laws. So that means, we want to see how many whistleblowers are making disclosures, how many are being investigated, what's the outcome of that investigation, and what's the impact of that investigation? Was there accountability? And what did that look like? And were there any remedies for the whistleblower? What did that look like? And if not, why? So there's a lot of indications, and the more kind of openness we have, the better. Now, we also suggest that laws remove economic barriers for whistleblowers who are challenging retaliation. There's a number of countries that have loser pay rules, and we did see those enforced against whistleblowers, where the whistleblower not only lost their case, which, as we've learned, it's more likely than not that a whistleblower is going to lose their case. So when they lost their case, they had to pay not just their fees, but the employer's fees. And that's really a significant factor in undermining the effectiveness of whistleblower laws, and would really chill anyone from bringing cases under that law and being able to rely on it. But it also means access to affordable legal assistance is really important. Legal representation can make all the difference in a whistleblower's case. All laws should include a periodic review of the law's effectiveness. We find that when that's built in to the legislation, and there's a process from learning from mistakes and learning from reality and implementation that allows us to go back to the whistleblower law, make amendments, and continuing to update it as a living, breathing thing where we can learn and strengthen the law to stop all of the loopholes. Now, we also recommend, and this is probably one of the most significant, I think, takeaways from this study, is that bias and discrimination have to be addressed through an intensive public education and training initiative. Whistleblowers often have a bad reputation, and they're not embraced by the public, or the public doesn't understand what a whistleblower is, or employees don't understand what their rights are, or maybe they don't even know that there is a whistleblower law that protects them, or if they know there's a law, they don't know where they can go for help. So we need public education, but we also need training, and training can happen in the workplace. There's a lot that heads of offices and organizations and companies can do, even just by setting a strong tone at the top and showing that they have, an open door policy, that they will not tolerate retaliation, and actually even going so far as to celebrate people who brought forward a disclosure within the company. And that's going to encourage employers to be able to actually get that information first, to be able to address those problems within their workplace, and not have, a scandal turn into a big, a public embarrassment, which actually can be very costly for the employer. So showing that employees who blow the whistle, who bring disclosures, have value, important value that they offer. And then finally, is that the utilization of technology for safe disclosures will make it easier, and it'll also lessen the chances of retaliation for whistleblowers. If whistleblowers' identities or identifying information is protected, then they can bring forward a disclosure without risking being found out who they are. So if they're scared of retaliation, if they're trying to protect their families and their interests, and then they can bring forward that information in a secure way. So it's really important that there's an investment in technology, in the secure reporting mechanisms, so that they can feel that there's some confidence in the process. And I just want to include a little bit about our study and our findings on gender. This is something that Rafaela spent a lot of time working on, and she's here today. And she took a look at all of the cases in this study, and she looked at the genders. And we found the gender by looking, of course, at the names of the whistleblowers. And we also looked at the gender pronouns that were used by the judge or the decision maker in their decisions. And we found that by and large, the majority of whistleblowers in this study overall were male, so 67%, while females accounted for just 30% of whistleblowers in the retaliation cases that we examined. There was a few that were unknown, and we put it in that category. Either their identity was protected, or the case involved more than one whistleblower. So it was a mixed gender case. So that was a sort of set aside, if you will. So overall, though, in terms of the win-loss rate, we found that the win-loss rate was fairly similar. So it sounds like you're sort of equally discriminated against if you're a man and you're a woman and you're a whistleblower. The whistleblower factor seems to be the predominant one. Interestingly, it was more pronounced in the United States, where we found that in 2018, 14% of women succeeded in their cases, and only 8% of men succeeded in their cases. So there was a more pronounced win-loss rate by gender that was actually favorable for women. But I don't want to end, just there. I think that there's a lot more that can be done to study gender and whistleblowers beyond just the quantitative data. I think we need more investment in qualitative studies to show the experience of men and women who are whistleblowers in their decisions to blow the whistle in the first place and their experience through the process. There's some indicators throughout where we saw a lot of women, for instance, withdrawing their case. So thank you so much for listening to us today. And I look forward to hearing any questions that you have.
This is so rich, and this was very educational and instructive. And thank you so much, both of you, for your patience in explaining to us. I have one question. I probably have many questions, but one thing that struck me in Tom's first, when Tom started speaking, and then throughout your presentation, about how the project started, and its closeness to the idea of free speech, and also to access to justice somehow. And then we come to this country, which is a country that has a lot of inequality, and obviously this reflects on the access to justice. And there is a trend, or we are now in a moment that some issues related to free speech are not so strong. I think that free speech is not as free as it used to be because of all the polarization and some political confusion. How do you think that, you study so many countries, and probably some of them have problems similar to ours or to other, how did you see the laws evolve or work or not work in countries which have similarities to ours?
I think the the key for nations where there's questions about the legitimacy or reliability of the formal legal institutions is that the whistleblower law is not limited to free speech towards government authorities. Those laws all too often are kind of like, they're almost like traps to identify people who are threats to the power structure. You have free speech rights. If you talk to the people you're blowing the whistle on, or the community that's supporting them. So the key is that the law protects freedom of expression to the public. And one of the most significant things that can make a difference is that it can protect civil society organizations, not just workers. In our experience, when the laws are very weak, and a lot of times in our experience, there hasn't even been a law in the United States for a particular type of problem. The key is solidarity. If the whistleblower can be basically laundering the truth through an NGO or civil society organization or institution or professional society that's got its own defense mechanisms, that organization can be the conduit for effective dissent that has an impact. Kind of the strategy is get the information into the right hands. And a lot of times the right hands will be people who are outside of official channels. So that means that a key feature of the law is that that type of speech is going to be protected. And you know, your insight is so universally well taken, and don't give the United States too much credit for actually having reliable justice, please, somebody who lives there. And if you look at the track records, the United States, the whistleblowers win about 10% of their cases. 1 in 10 chances, not very reliable rights. And that's compared to about 20% for the rest of the world in these countries that don't have as much freedom as the United States. They're actually doing twice as well. And that seems like it's still a real long shot for these rights. But compare that to 40 years ago. Then it would have been 0%. Now globally it's about 20% who can survive when they act on them. And in the United States, about twice as many cases end up getting partial relief through compromise settlements as through official victories. And that means about a third of the people who act on these rights are actually getting some benefit. And we didn't really have the resources to do that internationally, but the laws are making a difference, but they're not yet reliable. And until they're reliable, the key is solidarity for whistleblowers to break out of isolation, find allies who have a strong enough roots in society that it's not an act of martyrdom for them to follow through on the information.
If I could just piggyback on that real quick and just add that one of the things that we did in this study was beyond just looking at cases, and as Tom mentioned, it was sort of universal. It's difficult to be a whistleblower everywhere, but we did capture some sort of other cases that were not, there were whistleblower stories that were in the media and not necessarily final decisions of whistleblower cases. And why? Because some of those whistleblowers in countries that have a breakdown in human security and rule of law, the whistleblowers were disappeared or killed before they could even, dare, I think, to bring a legal case. And I think that's where you're really starting to see the differences. In some countries, you can have a whistleblower law, but it's still too dangerous to bring that free speech and to bring a case and be able to be physically secure throughout that process. And I think that that's something that's really alarming. I think we need to have that level of security and protection, physical protection for whistleblowers in order to be able to have whistleblower rights everywhere and anywhere.
Thank you.
Good question.
We have a couple of questions. I will make the questions here that are in the chat and then open to Martin to ask his question. So the first question is from Hazmi. I'm sorry if I pronounced it wrong. Shouldn't whistleblowers who are under professional confidentiality, such as lawyers, be held liable for breaches of confidentiality? And then another two questions from Felipe Rocchetti. The first one, did you notice any differences regarding effectiveness of whistleblowing programs when we focus on specific markets of products or services? And the second one is, do you know any empirical research about employability of whistleblowers? So I will let you answer to this, and then I will pass the word to Martin to ask directly his question, or if he wants to include here in the chat, we can ask it later.
I'll answer the first question and then give you a turn for the second query, Sam. The question about lawyers is an excellent question, and it's very fundamental. It goes right to the heart of contradictions in duties. The way the United States has handled it is that in terms of employment rights, a lawyer can blow the whistle. They can't be fired for blowing the whistle on their client who's an employer, like a government attorney, for example, or the general counsel of a corporation that's trying to stop fraud there. And oftentimes, it doesn't involve any public disclosure. It's that, in fact, 98% of whistleblowing is not public. It's internal. It's within the organization where the whistleblower works, is where they're engaging in freedom of speech. And they're retaliated for engaging in freedom of speech within their own organization. And the laws, the solid whistleblower laws protect that. So, oftentimes a lawyer is just doing their duty to the client by blowing the whistle internally and saying, you can't do this. It's going to violate the law and we're going to get in trouble. And then they get fired for getting in the way. But it also can involve providing testimony to government authorities or going public. And that conflicts with the attorney-client privilege and the confidentiality requirements of the profession. It's a separate track in the United States. The bar associations may have the right, and in some cases have, disciplined attorneys or even sought their disbarment for the same activities that lawyer couldn't be fired for by his employer, the government agency or the corporation. It's a very sensitive issue, and it's one that we think has to be balanced in any given situation. And even the Bar Association rights will say that, for example, you don't have an attorney-client privilege to cover up a murder. So there are limits to the principles, but it's subject to a very sensitive balancing test.
On the second question, which I think is about the differences in findings from the different types of employment sectors, through the study, and as I mentioned, kind of overall, there was just so few cases. So it was sort of difficult to study in a sort of a coordinated quantitative way, whether there were different outcomes in different sectors because it was such a large study and there were so many different sectors, but also to an extent, so few cases. But in the United States, for instance, I can say, for example, that we found that there were far greater cases in the public sector. And we saw that there were a lot fewer cases brought by private sector whistleblowers. But the indication, which we saw that I think it was about 30% of whistleblowers in our study from the United States, or private sector whistleblowers, prevailed in their case. but it was such a small sample size. And so if you're comparing that with public sector whistleblowers, where there was far greater cases and final decisions, we saw a lower success rate. But I think we have to kind of understand that, in terms of the sample size that we're looking at. So overall, no, we really didn't see any distinct differences that I think are particularly notable. But I can say, offhand that I think that in a country, for instance, that has these sort of KETAM, whistleblower awards statutes, where this is separate from retaliation cases, but if you bring information to the government and it results in a successful enforcement action, you may have an opportunity to get a reward of between 10 and 30% of what the government recovers. And so this is something that is afforded actually in reality to a very, very small percent of people who actually bring that information, and it takes years and years. But there are some people who, mostly white collar workers who have this access to information and can hire a terrific elite law firm to represent them. They'll be more successful, and in cases there's these large sort of rewards for whistleblowers. But if you're looking at the whistleblower cases, retaliation cases, or even whistleblowers who go to the Office of Inspector General, or they go through other government remedial agencies to bring information without a rewards program, you'll see, little justice, and certainly if there's a retaliation case, the rewards are very small. So I think if you look at the kind of the bigger picture as a whole, it's much more, I think, difficult to be a whistleblower if you are in a position of kind of a lower employment level and a lower income. Now, I'll also, I think, address the third question, which is about if there's any empirical research about the employability of whistleblowers. And I don't have any sort of global empirical research on the employability of whistleblowers. But I will say that from certainly our experience, there are a lot of our clients that we've worked with who've blown the whistle and have not been able to find jobs. And they've been blacklisted, and it's really hard to go through a legal process to challenge and prove blacklisting. And there's so many people who have stuck their necks out, who are driving Uber cars for a living, and these people are making large salaries, and are experts in their field, and we're no longer getting their expertise, we're no longer getting their knowledge. There was a few instances of President Biden hiring some whistleblowers who lost their jobs during the Trump administration, like Dr. Rick Bright, who's then appointed to the COVID-19 task force. And so this is a great way to utilize the skills of experts and people that we can rely on, for their bravery and their truth telling. So I think that tone needs to come from leaders, global leaders, as well. That it's okay to hire whistleblowers, and actually it's a good thing. So this does remain a serious issue that really needs to be addressed. And I think that there's things that governments and corporations alike can do to reverse that trend, and reward people who, that they can trust to bring information about wrongdoing or issues when they find that. It was a great question.
Great. And Martin, would you like to make the last question, because we are just have to finish.
I'll do it quickly then. Well,
Okay.
Thank you very much for the presentation. It was a great one. My question touches a point that you mentioned before, legal representation, right? And full disclosure, I've been the chief compliance officer for a large multinational, so I dealt with whistleblowing on a daily basis. Part of it, seen especially in the US, anecdotes shows that, look, a robust bar for whistleblowers, a robust legal representation really makes. Do you have empirical data to substantiate that? So that would be point one, or any correlation has been established somehow with your data? And second, in cases of country where there's not such a robust bar, and I think US is by far the most advanced one across the board, do you have data to substantiate that, for example, NGOs devoted to the protection of whistleblowers play an important role in putting up the ratios of whistleblowing and success ratios in cases of either getting a reward, which is a very powerful motivator, or to win in cases of retaliation cases? Does their research show any of those correlations? Thank you very much.
Thank you very much for those questions. And that's really the purpose of the study, is to be developing a base of hard data for these values and anecdotal experiences and insights. I think the most significant data on whistleblowing is the impact that it has for institutions, the benefits that it provides for those institutions. PricewaterhouseCoopers did a global study about 15 years ago of 80 major multinational corporations. In a huge percentage of them and were suffering from fraud against the institution, against the company, misconduct directed at the organization. And the audit found that whistleblowers were more effective in, well, first of all, it found that about 96% of them communicate their concerns internally and never break corporate regs, which was, we thought, a very significant finding. Most whistleblowers are acting to defend the institution where they're working rather than to attack it. But then within that context, they were more effective at exposing and catching fraud against the corporation than the audit departments, the compliance departments, and law enforcement combined. A few years later, there was a study by the International Association of Certified Fraud Auditors, came up with the same conclusions. These folks are generally trying to be a resource that's defending the organization and its mission rather than attacking the institution itself. When I give speeches to organizational leaders, I say, it's bad business to kill the messenger. There's a reason that's a legend, because it's so true. You need the flow of information in order to prevent significant problems before they fester and become more severe threats to the organization. As far as NGOs and their success and their role in whistleblower protection, I think they're essential because of two factors. One is they're independent from the institutions that possess the power and that the whistleblower may be challenging. So they don't have that conflict of interest. Second of all, they have specialized expertise that they've developed. And that's just absolutely essential for a whistleblower, both to behave responsibly and to behave safely and to have an impact. They need a navigator to guide them through the procedures and the tactics that are necessary to be a resource rather than someone who's just making noise and getting smashed in the process. So we think they're invaluable. And Samantha's reference to Pistolka, which stands for the whistle in Serbian, is a good example. They have an 80% success rate because they're there as navigators, not just as lawyers for the whistleblowers.
Can I add something? Hi. To Martine's question and also Felipe's, as a researcher in whistleblowing, finding data is extremely hard. I'll just give you the example of the gender study that Sam just mentioned in the presentation. Not only we have like very few disclosures in terms of the amount of cases, and for example, in this global study, we had 487 cases, and it's very hard to get any statistic relevance from, you know, this very small sample. But also we have the problem of the nature of this data, because so much of it is confidential. So we don't have access to, you know, what's been said and who said and what the result was. And even when we do get the data and we get to analyze it, for example, success or loss rates, it may hide other underlying circumstances. So, for example, we had this data that showed that perhaps women are winning more cases than men, but that does not make sense. Not that it doesn't make sense, but in reality, you will see that gender has other effects, either because, for example, women will be affected differently from men. So men will lose their job, women will lose their job, and perhaps their children, because they will lose, you know, their capability of sustaining their families or things like that. And so data won't tell the whole story of whistleblowing, and it's very challenging to research based on data only. So we need also this sort of like anecdotal facts to substantiate our findings. But if you're interested in other studies that do use data, I can also forward that to you. And there is a Brazilian group studying whistleblowing here in Brazil, and it's coordinated by Professor Carlos Arisson de Feld and Juliana Palma, and I was a part of that group as a research intern as well. And we'd love to connect with anyone who's on this topic. It's super interesting and very important. And thank you, Sam and Tom, for, you know, providing this overview of the study. It was really nice to be a part of it.
Thanks, Raphael. It was so great working with you on this study, and thanks for adding that. You made really great points. I think that what we don't have information on can be as interesting as what we do have information on, and hopefully, in the future we'll have better access to information. And I think our findings will be, that much more robust and inclusive at looking at different forms of identity or different layers and complexities in cases and comparing outcomes in different ways. So thank you so much to the organizers for having us today. It's really been our privilege, and we really enjoy all these really terrific questions that you all have. So thank you.
Thank you, Tom and Samantha. I know that you have a schedule after this meeting, so I won't keep you here, but it was great. Of course, there is a lot of questions, and I know that, as mentioned by Mariana, we have a lot of a long way to go here in Brazil, especially when you realize that our law, the anti-corruption law that was mentioned by Tom, which was enacted 10 years ago, does not pay any attention to individuals at all. So it's a protection for organizations only. And we have this culture in Brazil, so that the organizations have a lot of protection, but the individuals who make the organization does not. So we have a long way to go, and certainly a lot of questions from everyone. So it would be nice to keep in touch with you and make some progress in this discussion. Really, it was really, really nice to have you here. Thank you so much.